Oh, there it comes. So that's just a summary of what I explained on the whiteboard. So the first case we look at is Cundy versus Lindsay, and it's an Old English case going back to 1878. In this particular case, the fraudster wrote to the victim company, and he used an address and a name that was similar to a reputable firm on that street. So he used the name Belcarn, and the address was 37 Wood Street, and the reputable company Belk Iron traded from 123 Wood Street. So when the plaintiff got the letter, they thought they were dealing with a respectable firm, and so they dispatched goods to the fraudster's address. They then sought recovery of the goods, and the court held that if one examined the circumstances of this case objectively, the plaintiffs had always intended to deal with Belk Iron, in other words, with the reputable company and not the fraudster, and therefore the contract was declared void. So that's the first case, and it sets out that the contract was void. As such, legal title to the goods never moved from one party to another, and therefore the wronged party, or in our example over there of A, B, and C, A gets to keep the item. The second case of Phillips v. Brooks is where a fraud was committed in person. So the fraudster went into the shop, into a jeweler's, and he signed a check, and he said, and I'm sure he said it in a very early 19th century upper class English accent, "You see who I am Sir George Bullock." Obviously, Sir George Bullock was a person of some note and reputation in that time and place, and the jeweler was delighted to be serving Mr. George Bullock. He then sold him the ring, and he sold it to him as by way of check. Obviously, the check then bounced, and the question then became, was the contract void or was it voidable? The court held that it was a voidable contract. In other words, it was a valid contract until one of the parties made deliberate steps to get it set aside. In other words, until, for example, the jeweler went to the police and said, the check bounced, I think I've been the victim of fraud. Something along those lines to get the contract set aside. The court's logic in deciding it was a voidable contract is that the jeweler sold the ring not to Sir George Bullock, but to the person standing in front of him. That had he wanted to sell it to Sir George Bullock, he should have made more concrete and definite steps to prove or uncover the identity of Mr. Bullock. Effectively, what the court was saying is, you sold the ring to the person standing in front of you, therefore it was a valid contract until you make a conscious effort to set the contract aside. In other words, it's a voidable contract. In Ingram versus Little, there was a similar set of facts with a contrary conclusion. Again, it's a fraud committed in person. The fraudster went to the plaintiffs and made an offer to purchase their car. He offered to purchase the car by check, and when he did so, the plaintiffs refused. He then told them that he was Mr. P.G.M. Hutchinson, a prominent businessman, and gave his address. The plaintiffs then went and confirmed those addresses in the telephone directory, and it turns out that he wasn't the person who he said he was. The courts found that in that case, the contract was void. So in Phillips v. Brooks, even though it was fraud in person, it was voidable. In Ingram v. Little, the contract was deemed to be void. In other words, no contract existed, no contractual rights or obligations ever arose, there was no transfer of title. It was a dead letter from the word go. The court found that the identity of the purchaser in Ingram v. Little was of more fundamental importance than it was in Phillips v. Brooks. Now we'll get onto a discussion as to what the court's approach, or what the reasons behind the court's approach were, in just a second. But before we get to that, let's look at a couple of more cases and see where they decide which one of these two alternative approaches they decide on. The next case from the 1970s is Lewis v. Avery. It's right at the top of page 107. And the fraudster posed as a famous actor and proved he was a famous actor by showing a pass from Pinewood Studios, which is a big film studio in England. He then bought a car by cheque. The plaintiff accepted the cheque, and then the fraudster sold the car on to the defendant. So we have the classic example of the two-step process with the three parties that I drew on the whiteboard at the start of this discussion, where you effectively have the seller of the car was defrauded, the fraudster then sold the car on to an innocent third party, and the question then becomes, which of those two wronged innocent parties should be the one to lose out? The Court of Appeal in Lewis versus Avery followed Phillips and said the contract was voidable. So if the contract is voidable, it means title passes to the fraudster, and then title passes from the fraudster to the second purchaser, the third party, in this instance, Equities Darling. Now, it's important to point out that the contract is voidable, which means that if the plaintiff, or from our diagram over there, if A takes positive steps immediately after he finds out, let me start to explain that one again because it's an important point. By us saying the contract is voidable, it doesn't mean that you have to go to court to prove that the contract is voidable and have it set aside. You can take positive steps to get it set aside. So, for example, if A, when he sells the car to B, 20 minutes later realizes that he's made a huge mistake and that the cheque is a forgery, contacts the police and tells the police of what's happened, well, that'll be sufficient to set the contract aside. That'll be sufficient action for the contract to be avoided and to be set aside. So in Lewis versus Avery, Phillips was followed and the contract was deemed to be voidable. So unless the initial seller had taken any of these positive steps before the car was sold on to the innocent third party gets title of the car. What's the reason for the difference between these three cases of Phillips v. Brooks, Ingram v. Little, and Lewis v. Avery? Well, you could say that it all revolves around the importance that that should read importance of identity of the purchaser. You could say that it all swings around that the importance that the original seller places on the identity of the purchaser. I think a more realistic approach is that the courts were looking at these to try